Hello and welcome. This is part 2 of the court filings that were filed 2 days ago on October 16, 2024. I read the amicus brief from the ACLUM yesterday and provided commentary on it. This video will pertain to the Commonwealth's brief, which again was filed 2 days ago. And I wanted to refer to the Supreme Court's most recent filing in which they provided the deadlines for both the defense and the prosecution in the Karen Read case. I wanted to read this last sentence to you guys. And it reads, "The defendant's principal brief shall be filed no later than September 25th, 2024. And as we know, the Karen Read defense team did meet that deadline." And it continues, "The Commonwealth's brief shall be filed no later than October 16, 2024. And the Commonwealth did meet that deadline. But I want to show you how close they were to that deadline. And I want to read this last sentence. "The defendant's reply brief, if any, shall be filed no later than October 25th, 2024. So next week, if Karen Read's defense team does intend to file a reply brief, and I think they will, especially with the ACLUM amicus brief having been filed, which again helps their case against the prosecution. Anyway, yeah, I think they will. And so it's something to look forward to. It's not a definite, but I'm thinking they will. Again, I mean, I would, if I was Karen Read's attorney, I would definitely file a reply brief, knowing that the ACLUM has my back now, and they are arguing similar things I have argued and then some. They are only helping my case. So anyway, let's go to the Commonwealth's brief. And actually, before I go to the Commonwealth's brief, I just want to remind you guys of what the Karen Read defense team is asking the Supreme Judicial Court to do. And it's the 3 requests right here from Karen Read's filing. Number 1, whether the jury's final unanimous agreement following trial that Miss Read is not guilty of counts 1 and 3 constitutes an acquittal for double jeopardy purposes and precludes retrial on those counts. Number 2, whether Miss Read was alternatively entitled to a post-trial inquiry to substantiate her claim that the jury acquitted her of counts 1 and 3. Number 3, whether there was manifest necessity to support the declaration of a mistrial on counts 1 and 3, where 1, the jury was not deadlocked and in fact had reached a unanimous agreement on those counts. 2, the trial court provided no opportunity for Miss Read or her counsel to be heard regarding the declaration of mistrial. And 3, the record reflects no consideration of alternatives to a mistrial when in fact such alternatives existed and were codified in Massachusetts Rules of Criminal Procedure 27B. And if you guys remember the ACLUM amicus brief, they refer to Rule 27B as well, and they too are asking the Supreme Court of Suffolk County. They too are asking the Supreme Court for a post-trial inquiry / evidentiary hearing. And when I read this filing from the Karen Read's defense team, when they first filed it and I read it, I said that I was praying that they at least get number 2. That of all their requests, I hope, and in my opinion, their strongest argument is their request number 2, which again is the determination as to whether Karen Reed is entitled to a post-trial inquiry. And again, the ACLUM is requesting that she be entitled to a post-trial evidentiary hearing. So both the Karen Reed defense team and the ACLUM are asking the court, the Supreme Court, to order that the trial court, the superior court, listen to the jury members, determine if there were verdicts, and put those verdicts on the record. Okay, so it's important that we know what the requests were from the defense team, because the prosecution is supposed to answer to every single request. They're supposed to have a rebuttal to every single request, 1 through 3 here. So I will be reading the prosecution's, the Commonwealth's brief, expecting that they have an answer for number 1, number 2, and number 3. Now, this is how I found the Commonwealth's brief, the one they filed on October 16, 2024. I'm not sure why the first page is red, but it's how this website has it it's how the website provided it, okay? But the color on the first page, the first page is all red. It's really ominous, but you know, it's quite fitting coming from the Commonwealth, the prosecution. But I want to show you guys, look at the filing stamp right here, the time stamp. It was filed October 16, 2024, and look at the time. And if you can't see it, I'll zoom in. Look at the time. 4:14 p.m. And you guys remember the document I just read from the appellate court, from the Supreme Court. The Commonwealth had the deadline to file their brief. And that deadline was October 16, 2024. Okay? And remember, the ACLU filed their amicus brief in the morning on the 16th, and they filed it at 11:30 a.m. The Commonwealth filed their brief at 4:14 p.m. Guess what time, guys? Guess what time the Supreme Court of Suffolk County, guess what time it closes? It closes at 4:30 p.m. The fucking Commonwealth met the deadline by a few minutes. 16 minutes, guys. All right, so let's read this document, this ominous document. Okay. Commonwealth appellee versus Karen Reed appellant. On a reservation and report by the single justice of a petition for extraordinary relief pursuant to GLC 211 subsection 3, Commonwealth's brief for the Commonwealth, Michael W. Morrissey, corrupt district attorney for Norfolk District, Norfolk County, Caleb J. Schillinger, Adam C. Lally, Laura A. McLaughlin, assistant district attorneys. And what's funny is that in the more recent, the one before this, the filing that the Commonwealth provided before this, they did not include Adam Lally, but now they are including Adam Lally. Very interesting. All right. It shows the date, October 16, 2024. Table of contents. Okay. That's it. That's the table of contents. Table of authorities, issues presented, statement of the case, statement of the facts, and A through C, summary of argument. Okay. Okay, I'm wondering what this is. 1, 2, 3, 4. Okay. All right, just table of contents. All right, continuing through the authorities. All right. All right. I believe that's in Roman numeral 1. Issues presented. It reads, the jury reported 3 times in increasingly sharper terms that it was deadlocked. Its third and final note said that the jurors remained starkly divided, end quote, over, quote, the charges, end quote, and further deliberation, quote, would be futile, end quote. At no point did the jury express the prospect of unanimity on any charge, and the defendant argued at the time that the jurors were, quote, at an impasse, end quote, and, quote, hopelessly deadlocked, end quote. Did the trial judge abuse her discretion in declaring a mistrial based on the deadlock reported by the jury? Question mark. This is really fucking weird, the way they worded it and they ended it with a question. Who wrote this? It just seems really, I don't know, guys. The way it's written is really fucking off to me. Okay, I'm going to continue. Number 2, the defendant did not object to the declaration of the mistrial. The judge found that defense counsel had multiple opportunities to raise any objections, and she explicitly found not credible the defendant's assertions that the mistrial was sudden and unexpected, or that defense counsel was not afforded an opportunity to be heard. Did the judge err in concluding the defendant consented to the mistrial? And it ends in a question. Okay. All right, I'm going to continue reading. I might explain why it's peculiar to me, but maybe you guys already figure it out. If you read the defense's court filings, they aren't the form isn't like this. They had the 3 requests that we just read, and you'll notice that those requests are not in question form. There is no question mark at the end. And yet the prosecution is being peculiar here in their wording, in that they are concluding their statements with question marks, which to me seems improper. I'm just saying, it seems weird. Continuing, number 3. The jury did not return, announce, and affirm any verdicts in open court. Was the defendant acquitted of the charges of second-degree murder and leaving the scene? Question mark. So if, like I said, we just read what the defense is asking, and I'm going to go refer to that thing again, to the 3 questions, so we can compare the 2. Okay, guys, so again, just comparing the 2, this is what the defense is asking the Supreme Judicial Court to consider. Number 1, whether the jury's final unanimous agreement following trial that Miss Reed is not guilty of counts 1 and 3 constitutes an acquittal for double jeopardy purposes and precludes retrial on those counts. Okay, let's go to the Commonwealth's number 1. Okay, so again, this is the prosecution's number 1, and it's supposed to be a response, a rebuttal to the defense first argument, their first request. But it doesn't look like it to me, guys. It's almost like the prosecution took the opportunity to not respond to the defense, but to ask the Supreme Court for to ask them their own questions. It's really peculiar. Okay, I'm going to read it. So remember, the defense in their first request to the Supreme Judicial Court is asking whether, in fact, the jury did acquit Karen Reed on counts 1 and 3, and if because they acquitted Karen Reed on counts 1 and 3, that if it should preclude Karen Reed from retrial, right? Under the double jeopardy clause. That's the first request from the defense team. This is it's supposed to be the prosecution's response. It reads, their jury reported 3 times in increasingly sharper terms that it was deadlocked. Its third and final note said that the jurors remained, quote, starkly divided, end quote, over, quote, the charges, end quote, and further deliberations, quote, would be futile, end quote. At no point did the jury express the prospect of unanimity on any charge, and the defendant argued at the time that the jurors were, quote, at an impasse, end quote, and, quote, hopelessly deadlocked, end quote. Did the trial judge abuse her discretion in declaring a mistrial based on the deadlock reported by the jury? I'm saying, guys, it's so peculiar. So peculiar. Like, why is the Commonwealth taking this opportunity to as they're in this rebuttal? It's like they're asking the question, like their own questions. It's so weird to me. Again, I have followed a lot of court cases. I have followed a lot of court cases. Usually when one party files an argument through the court, the opposing party has to file a response to that argument. The defense in this situation filed 3 different requests, 3 different arguments, and it appears as though the Commonwealth responded to all 3, as the Commonwealth has listed here 3 statements, 3 answers, and yet they are also 3 questions. And it's just something I've never seen, guys. To me, it's a weird rebuttal. It's almost like I said, it's like instead of truly responding to the defense, truly having a rebuttal to the defense, the prosecution is simultaneously asking questions of the appellate court. And I'm just like, why didn't you file your own shit, prosecution? Why didn't you file your own post-trial inquiries to the Supreme Court if you've got questions? It's just peculiar to me. I don't know about you guys. I could be overanalyzing. That's totally possible here. But I'm telling you, the form is off. To me, it's unusual. I'm taken aback by it. And what's your opinion, guys? Is the prosecution actually responding to number 1? Are they keeping it relevant? Are they keeping their response to number 1 relevant? Are they actually responding to what the defense said? And it's like, yeah, in a way they are responding to it. This is their rebuttal. And they are, again, putting the onus on the defense right here. And even the judge herself did the same thing. And again, this is why it makes me feel pretty darn sure that Judge Beverly Cannoni is in cahoots with the prosecution. Because both Judge Bev and the prosecution have put the onus on the defense team that essentially says, the defense was cool with it. The defense didn't object, but now the defense wants to come crying. And that's the same fervor. Like, they both have it. Judge Bev and the prosecution, they have the same energy about this. It's so first of all, the prosecution's response to number 1 sucks. again, if I am a prosecutor and I have integrity, I'm going to look at what the defense is asking, and I'm going to be like, you know what? That's a good point, dude. I think we should ask the Supreme Court for a post-trial evidentiary hearing or a post-trial inquiry. You're absolutely right. Way to get to the bottom of this. We got to figure out if, in fact, there were unanimous verdicts on count 1 and 3, and we definitely have to figure out if that's going to preclude Karen Reed from retrial on those counts, because I, as a prosecutor, don't want to put someone in jeopardy. That's what a good, true prosecutor would do. But in my opinion, the prosecution here is muddying the waters. They are muddying the waters in that they're wanting the focus to be on the jury notes, which were ambiguous. They're wanting to defend the judge. They're wanting to defend the judge by asking the question, did the trial judge abuse her discretion in declaring a mistrial based on the deadlock reported by the jury? And again, how do we know that the jury at no point expressed the prospect of unanimity on any charges when it was only the foreperson was permitted to communicate with Judge Beverly Cannoni? And again, while the Commonwealth responds to number 1, not really responding to it, in my opinion, it's like, hello, prosecution, Adam Lally, Michael Morrissey, hello, didn't the fucking jury reach out to you guys? Didn't you guys receive emails and phone calls from the jury? Like, where is your fucking integrity? Why aren't you guys more serious about this? Why aren't you guys agreeing with the defense that we should know if there were verdicts, and we should know if those verdicts mean that Karen Reed should not be retried on those counts? Why? And again, these are like rhetorical questions, because what's really going on here, guys, is, again, a similar fervor that Judge Beverly Cannoni has, in that they want the focus to be on the notes. They want the focus to be on the defense's actions. They don't actually want to look at the big fucking picture, which is, were there verdicts? So I'm saying really disgusting so far. Let's go back to number 2 from the defense. So number 2 from the defense reads, whether Miss Reed was alternatively entitled to a post-trial inquiry to substantiate her claim that the jury acquitted her of counts 1 and 3. Let's go back to the prosecution's brief and see if they responded to number 2 accurately. So this is number 2 from the prosecution. The defendant did not object to the declaration of the mistrial. The judge found that defense counsel had multiple opportunities to raise any objections, and she explicitly found not credible the defendant's assertions that the mistrial was sudden and unexpected, or that defense counsel was not afforded an opportunity to be heard. Did the judge err in concluding the defendant consented to the mistrial? ? So guys, in your opinion, does the prosecution answer appropriately and with relevance? Does the prosecution respond to number 2 effectively? I think it's a really fucking weird response. Again, the whole questioning at the end really weird. Anyway, yeah, so they're not even, and guys, they're not even like, yeah, we should do a post-trial inquiry. They're not even about that. They're just, again, they're focusing on defending the judge. They're focused on defending the judge. They're focused on this non-argument that the defense did not object to the declaration of the mistrial. It's a non-argument because, again, the judge did not provide an opportunity for the defense or the prosecution to object to it. It's a non-argument. And it's also a non-argument in that not objecting does not constitute consent. And again, the defense provided case law. And again, the non-argument that the judge found that the defense counsel had multiple opportunities to raise any objection, and when in fact they did not. They did not have multiple opportunities to raise an objection. It's such a lie. That's not what happened. They were given no opportunity. Not even the prosecution was given an opportunity to object to the mistrial. It's as if, again, I will keep saying it, it's as if Judge Beverly Cannoni knew what the verdicts were. It's as if the prosecution knew what the verdicts were, and their behavior since then, the prosecution's behavior and Judge Beverly Cannoni's behavior since then, has been in defense of one another. You will notice they are defending one another. In my opinion, so far, number one and number two from the prosecution fails. It's not a response. Again, they fucking filed their response 16 minutes within the deadline. And it's, to me, so far, it's not a response. It's not a rebuttal. They are trying to prevent an inquiry from taking place. They don't want us getting down to the bottom of those verdicts. And again, what would a real prosecution do? Is this supposed to set the precedent for future prosecutions? Right? Are we supposed to accept that because the state and the government says this is correct and this is the right way, we're just supposed to follow it? We're just supposed to go along with it? Because that seems like how they are treating this. The Norfolk County DA. They're treating this as if it's this way because we said so. They are not in pursuit of the truth. And it is so clear already between the rebuttals to number one and number two. Let's go to number three from the defense. So again, number three from the defense reads, whether there was manifest necessity to support the declaration of a mistrial on counts 1 and 3, where 1, the jury was not deadlocked and in fact had reached a unanimous agreement on those counts, and 2, the trial court provided no opportunity for Miss Reed or her counsel to be heard regarding the declaration of mistrial, and 3, the record reflects no consideration of alternatives to a mistrial when in fact such alternatives existed and were codified in Massachusetts Rules Criminal Procedure Rule 27B. Okay. So again, that's number 3 from the defense. And that's the last time I'm going to refer to this document. So let's try to remember what the defense is asking here. So we are back to the prosecution's number 3. And guys, you know, the defense's number 3 was actually 4 parts. which makes it a little confusing, but follow along. The defense's number 3, they were asking, was there manifest necessity to declare a mistrial on counts 1 and 3? They were also asking whether, in fact, the jury were not deadlocked on count 1 and 3 and had actually reached unanimous verdicts. They're also asking whether the defense had an opportunity to be heard on the mistrial, the declaration of the mistrial. And the last part of number 3 is whether there were alternatives offered. The defense is saying there are no alternatives on the record, which there should have been for a mistrial. Before declaring a mistrial, the judge is supposed to seek alternatives. The mistrial is supposed to be the last ditch effort, right? It's supposed to be like, you do it only when you absolutely have to. And again, because there were multiple counts against Karen Read, Rule 27B of the Massachusetts Rules of Criminal Procedure applied. Because there were multiple counts. And why is that, guys? Why is that so important? Why does Rule 27B exist when there are multiple counts against a defendant? Because at any given time, any one of those counts could be a not guilty. At any given fucking time, any of those counts could be a guilty. That's why you have to know what the answer is to every single count before you declare a mistrial. You know, Rule 27B was a safeguard that Judge Beverly Cannoni did not even utilize, despite the multiple charges against Karen Read. Judge Beverly Cannoni acted that day as if it was her first time declaring a mistrial on multiple counts, as if she didn't know what she was doing. But I know she knew exactly what she was doing. The jury notes were ambiguous. The foreperson did not do his job. And again, according to the jury interviews conducted by Aidan Kearney, the foreperson was the only person permitted to speak with Judge Beverly Cannoni. The other members of the jury were not permitted to speak with Judge Beverly Cannoni. There was ambiguity there. Judge Beverly Cannoni was careless. She was not cautious. And she did not follow any rule. And the defense's number 3 is, to me, is quite thorough. It's a well-written request. Number 3 is. It's well written. You know, it's thorough. To me, it's like, why is the defense having to put up all these safeguards? You know, why is it up to the defense to ask all of these pertinent questions, crucial questions? Why is not the prosecution asking those crucial questions, but is instead, in their number 3, the prosecution is saying the jury did not return, announce, and affirm any verdicts in open court? And then, was the defendant acquitted of the charges of second-degree murder and leaving the scene? That's the prosecution's response to the defense's number 3. Which, again, to me is not a rebuttal. It's not a response. They are coming to the Supreme Court with their own fucking argument, with their own question. How is this proper? It's, guys, and try to, like, this is the defense's motion. The defense reached out to the Supreme Court. The defense filed a motion with the Supreme Court. If the prosecution had these questions, then the prosecution should have filed their own motion with the Supreme Court. Why is the prosecution taking the opportunity in the defense's motion to dismiss to ask these questions that the defense is not even asking? Again, this all reads rather improper to me. It's like a tit for tat with the prosecution. That's how I'm reading it, guys. For every number that the prosecution responded to, the prosecution had a counter argument, but it was a new argument. It was not an argument that the defense even provided. The defense didn't ask about count 2, and yet the prosecution is asking about count 2. The defense is asking about counts 1 and 3. But you will notice the prosecution is not fighting for those verdicts. Why does the prosecution want the focus to be on the fact that there was no verdict announced in open court? And why does the prosecution want the focus to be on count 2? When in fact the defense is asking about counts 1 and 3, among other things. I haven't even begun to read the document, guys, but I'm already like, what is this? And is the Supreme Court going to allow it? Like, to me, To me, the prosecution did not respond to the defense's arguments. And if I were the judge, I would see right through that. I would be like, you guys didn't even respond to what the defense has to say here. So I'm not even going to entertain your rebuttal here. It's disgusting to me, guys. It really is. Like, it's so, and despite the prosecution having hired on new attorneys and supposedly a new prosecutor for the Karen Read case, despite all that, they're still carrying the same energy, the same fervor. They're not out for the truth. And it's so evident already in their brief, just reading 1, 2, and 3. All right, I'm going to continue. Statement of the case. On June 9, 2022, a Norfolk County grand jury indicted the defendant, Karen Read, for murder in the second degree, GLC 265, subsection 1, manslaughter while operating a vehicle. We already know all these charges. Continuing, I'm just skipping through. A jury trial on the 3 indictments began on April 16, 2024. Beverly J. Canoni, J., presiding. On June 25th, 2024, the 37th day of trial, the jury began deliberating. In addition to the 3 charged offenses, the trial judge instructed the jury on 2 lesser included offenses of OUI manslaughter, involuntary manslaughter, by reckless, what is that? By wanton or reckless conduct? I wonder if it's a typo. I don't remember that word being there before, guys. 265 subsection 13 and 2 motor vehicle homicide by negligent operation while under the influence of alcohol. GOC 90 subsection 24GA. On July 1st, 2024, the 5th day of deliberations, the trial judge declared a mistrial based on jury deadlock. So that's the prosecution's narrative so far. And already the narrative is not accurate to what actually happened. Continuing. On July 8th, 2024, the defendant moved to dismiss the charges of second-degree murder and leaving the scene on double jeopardy grounds. The motion was accompanied by 2 affidavits from her attorneys. The Commonwealth filed a written opposition to the motion, and the defendant filed a reply. The defendant also filed 3 supplemental memoranda, each accompanied by an affidavit of counsel. On August 9th, 2024, the trial judge heard argument on the motion. In a memorandum of decision and order entered on August 23rd, 2024, the judge denied the motion. On September 11, 2024, the defendant filed in the county court a petition for extraordinary relief pursuant to GLC 211 subsection 3, seeking review of the order denying her motion to dismiss. A single justice, Elizabeth N. Juror, reserved and reported the case without decision for determination by this court. Statement of the facts, jury deadlock. So letter A, jury deadlock and mistrial. The jury began its deliberations on Tuesday, June 25th, 2024 at about 1:25 p.m. The deliberations continued over the next 3 days. On Friday, June 28, around noon, the jury foreperson sent the trial judge a note. We read that note. The judge asked the parties for their views on whether, at that point, the jury had engaged in, quote, due and thorough, end quote, deliberation. The Commonwealth, The Commonwealth. Seems like a part's missing. The Commonwealth, if a jury after due and thorough deliberations. Hang on, that might be a citation. Okay, it's a citation. Sorry, I'm not going to read the citation. The Commonwealth asserted that the jury had not had sufficient time to deliberate, and it was therefore too soon to give a Tui Rodriguez instruction. The Commonwealth noted that although the jury said it had not reached a unanimous verdict, it did convey that doing so would not be possible. The defendant disagreed with the Commonwealth's, quote, characterization of the note, end quote, and argued that the jury was, quote, communicating to the court that they've exhausted all manner of compromise, all manner of persuasion, and they are at an impasse, end quote. Defense counsel asked the judge to give the Tui Rodriguez instruction. The judge ruled there had not yet been due and thorough deliberations. Given the length of the trial, the amount of evidence presented through 74 witnesses and 657 exhibits, the complexity of the issues, and that each of the prior days of deliberations had been shortened, she instructed the jurors to continue deliberating. They deliberated until about 4:15 p.m. when the judge released them for the weekend. Deliberations resumed on Monday, July 1st. Around 10:45 a.m., the jury sent the judge the following note. We've read that note too many times. It continues, the judge again requested argument on whether there had been due and thorough deliberation. The Commonwealth acknowledged the length of the deliberations up to that point, around 22 or 23 hours in total, by its estimation, but it argued that the jury still had not conducted a thorough deliberation considering the trial length, voluminous evidence, and complex issues. The defendant argued it was, quote, time for a Tui Rodriguez, end quote, as the jury had, quote, come back now twice, indicating essentially that they were hopelessly deadlocked, end quote. Do you guys see this? The prosecution is using the same formula that Judge Beverly Cannoni used in her own court filing. They are continuing to put the onus on the defense, rather than, again, looking at the big picture, rather than putting the focus and the energy on whether or not there were verdicts. The prosecution and the judge are sort of using the same formula here in their responses to the defense, both in the trial court and now in the Supreme Court. The prosecution took all the bullshit they used in the Superior Court and they are applying they are applying that same bullshit to the Supreme Court. And they are consistently, just like Judge Beverly Cannoni, the prosecution and Judge Beverly Cannoni are consistently putting the onus on the defense, as if they are blaming what happened during trial on the defense. That the Judge Bev would not have declared a mistrial if it were not for the defense's actions. Look at the defense quoting, they were hopelessly deadlocked. Even the defense considered that the jury were hopelessly deadlocked. When in fact, guys, actually right now, today is what, October 18, 2024? As of October 18, 2024, both the prosecution and Judge Beverly Cannoni herself know that the jury were unanimous that Karen Read was not guilty of counts 1 and 3. Look at what they do despite that knowledge. They want the focus to be on the defense. They don't want the focus to be on the resolution, on the solution. They don't want the focus to be on the fact that the jury came forward post-trial to the defense and to the prosecution and said that Karen Read was not guilty of counts 1 and 3, and that Judge Beverly Cannoni herself, in her own publicly available court filing, said that those verdicts were true and accurate. But because they weren't announced in open court, she's not going to do a damn thing about it. And look at the fucking prosecution. Just using the same circular arguments and blaming the defense for the declaration of the mistrial. When in fact, the declaration of the mistrial is entirely, completely on the judge for not doing her fucking job. Again, I made a video about this a while ago, and it was titled something like, Michael Morrissey thinks you're an idiot, or Michael Morrissey thinks we are all idiots. And my stance has not changed. In fact, the more that the prosecution speaks, the more that Judge Beverly Cannoni speaks, the more I know that Michael Morrissey, the district attorney of Norfolk County, thinks I'm a fucking dumbass. He thinks you're a dumbass. He thinks we are all idiots. That if he just pushes these arguments, these distractions in our faces, then we won't focus on the big picture. The big picture being that actually Karen Read was acquitted on counts 1 and 3. Continuing to read. Defense counsel again asked the judge to give the instruction. The judge found that the jury had engaged in due and thorough deliberation, noting the jury had been, quote, extraordinary, end quote, and that she had, quote, never seen a note like this reporting to be at an impasse, end quote. She gave the jury the full Tui Rodriguez charge, and deliberations resumed. At about 2:30 p.m. that same day, the jury sent another note to the judge. The parties returned to the courtroom. The case was called, and the judge informed counsel, quote, the jury is at an impasse, end quote. After the jurors entered the courtroom, the judge read the note aloud. And we've all read that note. Not reading it again. And it remains ambiguous, folks. It remains ambiguous. it says they are at an impasse. It does not say which count they are at an impasse, for which they are at an impasse. It's ambiguous. And again, it would not have been ambiguous if Judge Beverly Cannoni simply followed the rules of criminal procedure. Continuing, the judge told the jurors, quote, "I am not going to do that to you, folks. Your service is complete," end quote. She declared a mistrial and excused them to the jury room, where she said she would see them, quote, "in a few minutes," end quote. The judge and counsel remained in the courtroom and scheduled a date to return for a status conference. B. Purported post-trial juror statements. Purported, guys. Purported. I'm going to keep reading, but purported already makes it seem like it's almost like saying it's alleged. I'm going to keep reading, though, to find out. 1 week later, on July 8th, the defendant filed her motion to dismiss, along with affidavits from her counsel, attorneys Alan Jackson and David Unetti. Attorney Jackson's affidavit stated that on July 2nd, a purported juror, Juror A, contacted him. He said he was able to identify which juror they were from his conversation with them. I have to read that again. He said he was able to identify which juror they were from his conversation with them. That's not okay. It's okay. It's how they wrote it, guys. According to Attorney Jackson's description of the conversation, Juror A said the jury had unanimously agreed that the defendant was not guilty of second-degree murder, count 1. And, quote, shortly following that deliberation, end quote, they also had unanimously agreed that she was not guilty of leaving the scene, count 3. Attorney Unetti's affidavit stated he had received communications from 2, quote, informants, both on July 3rd. He said, one of these informants, Informant B, sent him a screenshot that Informant B had received from some other person, quote, intermediary B. Of why it's really poorly written, folks, of text messages that intermediary B allegedly had received from a purported juror, Juror B. Attorney Unetti believed he could confirm Juror B had been a deliberating juror based on a first name for Juror B given to him by Informant B. According to Attorney Unetti's description of the screenshot, Juror B allegedly texted intermediary B, quote, "It was not guilty on second degree," and split in half for the second charge. When the judge sent us back with that Hernandez thing, which, pulling away, guys, the juror meant Tui Rodriguez, not Hernandez. Continuing to read. Hernandez thing to look at the other side, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. And again, the revision of that statement is no one thought she hit him on purpose or even knew that she hit him on purpose. I don't know why the prosecution is continuing to use statements that were already corrected, and why they continue to use the word purported, other than to almost discredit what the defense is saying here, even though the jurors also reached out to the prosecution, folks. Continuing to read, Attorney Unetti stated that the other informant, Informant C, had contacted him to say that they personally knew a purported juror, Juror C, as they... You know, guys, this is a lot of waste of breath right here. It's a lot of waste of fucking time for the prosecution to just almost copy and paste their previous court filings and say, and repeat to the court and to the rest of the world what we already know about jurors A, B, C, D, and E. We already know this. Why is the prosecution not sticking to the defense's filing? They are just like bringing up they're rehashing what we already know, and they don't know they don't necessarily have to do this. That's what I'm getting. Like, they don't have to do this. And to me, this is like almost like it's almost like they're putting this on display for the Supreme Court on purpose. This is strategic to say, look at all this, Supreme Court. Look at all this, appellate court. Look at, what are we supposed to believe? Look at all these informants and intermediaries and all this hearsay, purported people that were supposedly part of the jury. To me, this is part of the prosecution's angle. They almost want to bore us to death, just like it was Adam Lally's angle during trial. He wanted to bore all of us to death with bullshit. Okay, I'm gonna keep reading so I don't take forever. I'm gonna skip down because we already know about the informants. Yeah, we already know about all this. It's like reading the jury notes over and over again. For what? We already know the jury notes. And it doesn't matter how many times we read the jury notes. The jury notes were not specific. They were ambiguous. It was up to the judge to provide clarity. It was up to the judge to determine with certainty, without ambiguity, what the counts were, what the conclusion of each count was, if any. And she did not. All right, I'm gonna read this part. Okay. On July 10, Attorney Jackson submitted a supplemental affidavit stating that on July 8, he was contacted by a purported juror, Juror D. He said he was able to identify which juror they were from his conversation with them. According to Attorney Jackson's description of the conversation, Juror D said the jury had unanimously agreed the defendant was not guilty of counts 1 and 3, and the jury's disagreement was solely as to count 2 and its lesser included offenses. Attorney Jackson submitted a second supplemental affidavit on July 18. He stated that he had been contacted the day before, July 17, by a purported juror, Juror E. He again said he could identify the individual as a deliberating juror. According to Attorney Jackson, Juror E said the jury was, quote, unanimous on 1 and 3, end quote. The defendant was not guilty, and the jurors deadlocked only on, quote, lower charges on count 2. On August 1st, 2024, the Commonwealth filed in the trial court a notice disclosing that on July 2nd, an unsolicited voicemail was left on the office phone line of one of the trial prosecutors. The caller, who identified themselves as a juror by full name and seat number, stated, quote, it is true what has come out recently about the jury being unanimous on charges 1 and 3, end quote. The same individual left another unsolicited voicemail for the prosecutor on July 26, stating that they, quote, can confirm unanimous on charges 1 and 3 as not guilty, and as of last vote, 9-3 guilty on the manslaughter charges, on the lower level manslaughter charges, end quote. The Commonwealth's notice further disclosed that it also had received emails from 3 individuals who identified themselves as jurors and wished to speak unanimously. The Commonwealth had responded to the emails by stating that although it would welcome the opportunity to discuss the evidence or its case, it was ethically prohibited from inquiring into the substance of the jury deliberations and could not promise confidentiality, as it might be required to disclose any such communications to the defendant or the court. And as we pulling away from the filing, as I determined, that was a complete lie, especially confirmed by the very recent amicus brief that was filed by the ACLUM. That was a complete lie. That, in fact, there are plenty of instances in which the jury is called back post-trial to determine what verdicts were. It's not out of the norm. It's not like new case law needs to be created, unlike what mainstream media tried to imply. In fact, juries are called back to court post-trial to determine what verdicts were. And it has happened in Massachusetts before. The Karen Reed case is not a new situation. But the prosecution and Judge Beverly Cannoni continue to lie to us. They continue to portray this as a new situation. They continue to tell us that this can't be done. Continuing, all three individuals declined to communicate further with the Commonwealth and provided no information about the jury's purported votes. On August 5th, Attorney Yannetti submitted a supplemental affidavit stating that he had received an unsolicited phone call on July 31st. The caller said they had been a juror in the case, and based on what they represented to Attorney Yannetti to be their full name, Attorney Yannetti stated he was able to confirm that the caller was the person identified as Juror B in his prior affidavit. According to him, the caller said the jury had reached unanimous not guilty verdicts on, quote, indictments 1 and 3, end quote, and had been deadlocked only on, quote, indictment 2, end quote. The caller also said they were familiar with Attorney Yannetti's prior affidavit, and the text message exchange referred in paragraph 4 of the affidavit was accurate, except that they had meant to write, quote, no one thought she hit him on purpose or even knew that she had hit him on, end quote. And again, I provided that correction. I wish the prosecution would have stuck to the point, but again, we're talking about the prosecution. The bar is rather fucking low. Continuing to read. The caller, quote, believed that other jurors had been reluctant to come forward because there is so much public and media attention focused on this case, end quote. Letter C, juror privacy and safety concerns. It already screams bullshit. Continuing. On July 8th, the same day the defendant filed her motion to dismiss, the trial judge sua sponte issued an order impounding the list of names of the impaneled jurors. The judge noted that the case had, quote, garnered significant and divisive attention in Massachusetts and across the nation, end quote, and that the proceedings continued to be, quote, the daily subject of commentary on various social media platforms, end quote. She noted, too, that, quote, people associated with the case have been charged with intimidation, end quote. She found that there was a real and present risk of personal harm to the jurors and to the integrity of their service if their names were to be made available to the public at that time, and thus a risk of immediate and irreparable injury, establishing good cause to impound the list. The order stated that it would expire 10 days from its issuance unless otherwise ordered by the court for good cause shown. On July 18, one of the deliberating jurors, represented by counsel and proceeding under the pseudonym, quote, Juror Doe, end quote, filed an emergency motion for an indefinite extension of the impoundment order. The motion was supported by an affidavit from Juror Doe. Juror Doe averred that they feared for their personal safety and the safety of their family if the jurors' names were made public. In addition to the conduct noted in the impoundment order, Juror Doe recalled trial testimony from at least one witness who had described herself and her family being harassed because of her involvement in this case. Juror Doe also stated that during deliberations, the jurors, quote, could hear protesters outside screaming and yelling, end quote. But, okay, pulling away from this, guys, if you guys remember the jury interviews conducted by Aidan Kearney, I believe one of the jurors he interviewed said that they could not hear the protesters. But I don't know. Either way, guys, protesting is not illegal. It's not illegal to be a protester or to have a demonstration outside of a courtroom. That's not illegal. And I get that maybe some jurors would feel pressured by crowds outside the courtroom. It might make them nervous. But has there been any instance of a protester attacking a juror in the Karen Read case? Like, I'm just saying, guys, like, where's the fire? Continuing to read. And after the jurors were discharged and transported by bus back to what was supposed to be a secret location, they were met there by what appeared to be members of the media, including photographers. Juror Doe cited recent examples of news articles and social media commentary in which individuals had expressed anger at the jurors, sought to identify the jurors, and advocated publicizing the jurors' home addresses, occupation, and other identifying information to harass and shame them. In closing, Juror Doe said, my affidavit and motion should not be interpreted as indicating how I or any other juror voted on this case, or how I or any other juror feel about this case. Every member of the jury, regardless of how they voted, is likely to face backlash from a segment of the large portion of the public who intensely followed this case. I wish to remain anonymous, and I bring this motion on behalf of myself and any other juror who does not wish to be identified, regardless of whether or not we agreed during our deliberations. It was an honor to serve on the jury. It also was a significant sacrifice of time, which I understood and anticipated when I was selected. What I did not anticipate, however, was the likelihood that I and other members of the jury would become targets of intense public scrutiny and likely harassment campaigns strictly due to the outcome of our private deliberations. If jury names are made public, I will be subject to nonstop requests for comment about jury deliberations. I would prefer to not have to respond to these inquiries. However, what I fear is not only will I be subject to requests for interviews, but that I will be targeted and harassed because of what I did or did not do on that jury. I fear that verbal harassment will likely lead to physical confrontation and physical harm. I am not prepared or equipped to anticipate and prepare for any surprise personal attack. More importantly, I fear that I will not be able to protect myself and my family. The trial judge credited Juror Doe's affidavit and found that Juror Doe had established good cause to extend the impoundment order unless and until otherwise ordered by the court. Continuing. Summary of argument. The trial judge soundly exercised her discretion in declaring a mistrial on the ground of manifest necessity. That's a lie. Again, this is the prosecution, guys. That's a lie. They are they are not after the truth. They're just Judge Bev, she's all about defending the prosecution, and the prosecution is all about defending Judge Bev. It's a circular thing going on, and it goes nowhere. And neither the judge nor the prosecution are asking the crucial questions. Were there verdicts? Were there verdicts, and was Karen Read acquitted? And if so, then she should not be retried. Again, neither the judge or the prosecution are asking those questions. They want to pretend they care about jury safety. They want to pretend they care about the jury, when in fact, if they cared about the jury, they would allow the jury to come back so that the jury could announce their verdicts. Continuing to read. The jury repeatedly reported it was deadlocked and further stated that continuing to deliberate would be futile and only force the jurors to compromise their deeply held beliefs. This sentence also sucks. Because again, is the prosecution talking about which count the jury were deadlocked on? Which count were they deadlocked on, Michael Morrissey and Adam Lally? Which count were they deadlocked? Continuing to read. The jury gave no indication it had reached a unanimous verdict on any charge, and the defendant argued at the time against finding any such unanimity. And that's not true either. The defendant argued at the time against finding any such unanimity. What? I'm going to read that again, guys. The jury gave no indication it had reached a unanimous verdict on any charge, and the defendant argued at the time against finding any such unanimity. What? That didn't happen. The defendant, the Karen Reed's defense team argued against finding out whether they were unanimous on any charges. When did that happen? That didn't happen during trial. That did not happen during trial. And again, the prosecution is focusing on what happened during trial. They are not focusing on what the defense is actually asking for, which is what happened after trial, post-trial. There were verdicts post-trial. The defense and the prosecution found out that there were verdicts. Judge Bev herself considered those verdicts true and accurate. But here's the here's the prosecution, once again, putting the focus on what happened during trial, while we all know that what happened during trial was a fuck up. What happened during trial should never, ever, ever happen in a fucking trial where there are multiple counts against a defendant. There should never, ever be an assumption that the jury are all deadlocked on all the counts. There should absolutely be a judge with a moral compass to just refer to the fucking rules and ask the jury which counts are they deadlocked on? Which counts are deadlocked and which ones are not? Continuing. There was no viable alternative to a mistrial, but even so, the defendant was afforded a meaningful opportunity to be heard on any purported alternative. That didn't happen either, prosecution. Prosecution, you were there. The prosecution was there, and not even the prosecution was given an opportunity for an alternative. There was no fucking alternative, people. There was no alternative. The Tui Rodriguez instruction is not an alternative. The Tui Rodriguez instruction is a push to the jury to make a decision. That's all it was. The judge declared a mistrial without seeking any alternatives. And like the ACLU determined, and like Karen Reed's defense team determined, a really good alternative would have been to inquire as to each count. That would have been an excellent alternative to declaring a mistrial. But instead, the judge made no alternative moves. She declared a mistrial without seeking alternatives. Continuing. And guys, I've read multiple sentences here and I can't even read the next sentence without stopping because every single fucking sentence is a lie. Continuing. Even assuming there was no manifest necessity, the trial judge properly ruled that the defendant consented to the mistrial. Even assuming there was no manifest necessity, the trial judge properly ruled that the defendant consented to the mistrial. When in fact, the defense provided case law. The defense provided case law that not objecting to a mistrial cannot be assumed to be consent to the mistrial. That argument is dead, prosecution. But they copy and paste their arguments between their filings. They have provided nothing new, guys. Continuing, the possibility of a mistrial because of deadlock was clear, and the jury's first note. Okay, I'm going to read that again. The possibility of a mistrial because of deadlock was clear from the jury's first note. I read that really wrong the first time. Okay, I'm going to try to do it again just to... I need the clarity. The possibility of a mistrial because of deadlock was clear from the jury's first note. And clearer still from its second note. Defense counsel consistently pushed for that result in response to those notes. Had ample time to prepare for a mistrial before it was later declared, and raised no objection despite multiple opportunities to do so. Again, all lies, guys. All lies. The possibility of a mistrial because of deadlock was clear from the jury's first note. Actually, that was not clear from the jury's first note. And clearer still from its second note. No, that wasn't clear. Again, there were multiple counts. And the notes, not one of the notes specified which counts they were deadlocked on. Which counts were their deadlocks? The prosecution didn't know because not one note specified. Continuing, defense counsel consistently pushed for that result in response to those notes, had ample time to prepare for a mistrial before it was later declared, and raised no objection despite multiple opportunities to do so. Every single word in that sentence is a lie. Defense counsel consistently pushed for that result in response to those notes. No, they did not push for that result. The defense counsel pushed for a Tui Rodriguez. They were denied the first time, and then the judge agreed with them the second time. The prosecution, again, much like Judge Beverly Cannoni, is implying that the defense wanted a mistrial, when in fact the defense never once requested a mistrial. They requested a Tui Rodriguez. Again, guys, in what courtroom would the mistrial be dictated by the defense? In what courtroom? The defense is not the judge. The judge makes the determination of a mistrial, whether a case should be a mistrial. Do you see the similarities between the prosecution and Judge Beverly Cannoni? Do you see the similarities in how they argue and how they both put the onus on the defense consistently, time and time again? It is the defense's fault that a mistrial was declared. and the defense had an ample opportunity when in fact they did not. Not even the prosecution had opportunity to comment on the mistrial. Continuing, the defendant's personal assent to the mistrial was not required. The defendant was not acquitted of any charge because the jury did not return, announce, and affirm any open and public verdicts of acquittal. That requirement is not a mere formalism, ministerial act, or empty technicality. It is a fundamental safeguard that ensures no juror's position is mistaken. That's bullshit. Look at them. Look at this, guys. Look at the again, the blame shifting. And look at how they are taking the defense's, one of the defense's arguments pertaining to safeguards. The prosecution is actually arguing that not announcing a verdict in open court is a safeguard, when in fact it's not a fucking safeguard. It is a fundamental safeguard that ensures no juror's position is mistaken. What about Rule 27B, prosecution? That Rule 27B is actually a safeguard that ensures no juror's position is mistaken. The prosecution and Judge Beverly Cannoni mistook the jury's position because they did not rely on the rules of criminal procedure. Continuing to read. Ensures no juror's position is mistaken, misrepresented, or coerced by other jurors. It also protects each juror's right to rethink their position and to change their vote before reaching a final verdict. The alleged post-trial statements from certain purported jurors do not constitute acquittals, and the judge properly denied the defendant's request for a post-trial inquiry of the jurors. That inquiry would necessarily require delving into the jurors' deliberation, which this court has consistently and firmly held impermissible. Guys, as I have said, and so that I'm not yelling into your ear, they have copied and pasted their arguments from previous court filings. They have provided nothing new, nothing of substance. Nothing of substance. My apologies. As they use and reuse the same argument that Judge Beverly Cannoni herself used. As they use and reuse the same argument that news anchors from mainstream media used, as if the news anchors themselves received the same memo. Michael Coyne. That inquiry would necessarily require delving into the jurors' deliberations, when in fact, figuring out what the verdicts were have nothing to do, are entirely separate and apart from the deliberations. The deliberations is the process. The verdicts are the conclusion of the process. Do you guys really think that the Norfolk County DA's office doesn't know this? Do you guys really think Judge Beverly Cannoni doesn't know this? They don't know how to differentiate the two. They don't know that the deliberations is the process and the verdicts are the conclusion of the process, and that you don't necessarily need to know. You don't necessarily need to know what happened during the process in order to determine the conclusion. Do you guys really think neither the judge nor the prosecution know this? Oh my gosh, guys, if they don't know this, I don't know how the fuck they ended up where they are today. They are playing dumb. They want our eyes on the deliberations. They don't want our eyes on the conclusion of the deliberations. Continuing. Argument 1. The judge soundly exercised her discretion in declaring a mistrial where the jury repeatedly reported it was deadlocked, gave no indication of unanimity on any charge, and stated that further deliberations would be futile. Double jeopardy principles do not bar retrying a defendant when a mistrial is declared as a matter of manifest necessity. Manifest necessity is another way of saying that in a particular case, the right of a defendant must yield to that of the public. A deadlocked jury is the, quote, prototypical example, end quote, of a manifest necessity justifying declaration of a mistrial. But again, they use and reuse arguments without actually getting anywhere. They are okay with the ambiguity. They are okay with the careless, reckless declaration of a mistrial. They don't even care that the jury were at an impasse and that the world doesn't know, or the world was not told which count the impasse applied to. The prosecution and the judge are perfectly okay with the ambiguity because it goes in their favor. Continuing. Case law. Bullshit case law. In parentheses, trial judges' belief that jury is unable to reach verdict, quote, has long been considered the classic basis for a proper mistrial, end quote. Yeah, but again, using and reusing the same argument, but getting nowhere with your argument, prosecution. Guys, if you are ever in a relationship with somebody that does this, that you give them an argument and they give you circular arguments in response, like the prosecution is doing here, run. Get the fuck away from them, because this is an abusive relationship. The prosecution are abusers. This is abusive. They are oppressive. They don't want to get down to the truth. They want to defend themselves, and they want to defend the judge, and the judge wants to defend them. Nobody is thinking about the jury. The only people thinking about the jury is the defense team and the ACLUM. Much like what happened on January 29th, 2022. Nobody was thinking about John O'Keefe. The only one who was thinking about John O'Keefe was Karen Reed. Guys, this is what corruption looks like. This is what fucked up people look like. This is how they speak. You get nowhere with them. And the truth is always far away, not within reach. You're never going to get it from abusers. You are never going to get the truth from abusers. It's impossible. Continuing. On review, quote, the question for decision is whether the petitioner has shown an abuse. Funny enough, huh? Funny enough that I just used the word abuse, and here's the prosecution. Continuing. Quote, the question for decision is whether the petitioner has shown an abuse of discretion by the trial judge in declaring a mistrial, end quote. This court accords, quote, great deference to the trial judge's determination when a mistrial is premised upon the trial judge's belief that the jury is unable to reach a verdict, end quote. The propriety of a deadlock-based mistrial, quote, is not answered by application of a mechanical formula, end quote. It's like, what the hell is the prosecution even saying? What the hell are they fucking saying? They're saying nothing. Continuing. It is a circumstantial inquiry, and the quote, pertinent factors, end quote, correspond to those informing whether the jury has conducted due and thorough deliberation under GLC 234A subsection 68C. These factors include the time spent deliberating relative to the length of the trial, the complexity of the disputed factual issues, and, quote, statements by the jury that they cannot agree, end quote. Here, after deliberating across 4 days, the jury told the judge it had exhaustively reviewed the evidence and diligently considered all disputed evidence, but had been, quote, unable to reach a unanimous verdict, end quote. Again, a unanimous verdict on which count? Unable to reach a unanimous verdict on which count, prosecution? Continuing, considering the jury's note, the extent of deliberations thus far in view of the trial length, the amount of evidence presented, and the complexity of the issues to be decided, the judge found the jury's deliberations had not yet been due and thorough, and she instructed the jury to continue deliberating. On the next day of deliberations, the jury sent the judge a second note stating the stronger terms. We already read this. Deeply held convictions. Considering again the jury's statements and the additional time spent deliberating, the judge found the jury had conducted due and thorough deliberation and provided the Tui Rodriguez charge. Later that afternoon, the jurors returned a third and even more emphatic note that said, "We continue to find ourselves at an impasse." All right. Yep. Deeply divided. Yep. Principles and moral convictions. Yeah. 4-person. Yep. Deeply held beliefs, 4-person. But you didn't specify which counts, 4-person. And was that on purpose, 4-person? Continuing, the judge, quote, had no doubt based on the jury's notes to the court that it was unable to reach a unanimous verdict, end quote. It was also, quote, clear, end quote, to her from the third note that the jurors, quote, would not consent to continuing their deliberations, end quote. Quote, I am not going to do that to you, folks, end quote. And at that point, the jurors could not be compelled to continue deliberating without their consent. Yeah. But again, Rule 27B, multiple counts. There were multiple counts. And because the judge didn't do her job and because the prosecution didn't make sure that the judge did her job as the prosecution, the notes and the conclusion were ambiguous. Continuing, in short, the judge's declaration of a mistrial due to deadlock was informed by her consideration and weighing of the specific factors pertinent to that decision. She did not abuse her discretion. No, in fact, she did. Pulling away. Again, isn't it crazy, guys, how the judge defends the prosecution and the prosecution defends the judge so consistently over and over and over again? Continuing, the defendant nonetheless claims the judge erred by failing to consider alternatives to a mistrial and to give defense counsel an opportunity to be heard. As to purported alternatives, she contends the judge should have inquired whether the jury had reached a unanimous verdict on any charge or asked the jurors if they would consent to further deliberations. The judge was not obligated to make, quote, either inquiry as a matter of course, end quote. In parentheses, judge under no duty to inquire about possibility of unanimous verdicts or willingness to continue deliberating, end quote. It just sounds like a lot of bullshit to me, guys. Continuing, in parentheses, rejecting argument that judge needed to give effect to any potential unanimity on charges before declaring a mistrial because of hung jury, provides a case law. In parentheses, judge not required to receive partial verdicts under Mass Art Crim P 27B. in parentheses, judge has discretion as to partial verdicts. Again, none of these apply. Guys, I really want you guys to know this. None of these case laws apply when in fact there were multiple charges against Karen Read. That's what Rule 27B is designed to do. It's designed to be a safeguard against multiple charges. Judge Bev was supposed to require the jury to return verdicts on every single charge so that there would not be any ambiguity. Continuing, quote, the circumstances before the judge also did not necessitate either inquiry, end quote. There was no reason for the judge to ask if the jurors would consent to further deliberations. The jurors' final note made abundantly clear that they did not consent and that if they continued to deliberate, any verdicts reached would not have been each juror's, quote, own verdict, the result of their own convictions, but rather, quote, a mere acquiescence in the conclusions, end quote, of the other jurors, provides a case law. But again, circular arguments here. The jurors' final note made abundantly clear. That's inaccurate. That's an extremely inaccurate description of what that final note read. The final note pertained to an impasse, and the final note did not specify which count the impasse applied to. It was not abundantly clear. Every sentence in this filing is a lie. Continuing, in parentheses, trial judge best positioned to assess whether jury able to reach just verdict if deliberations continue, end of parentheses. There was also no basis for the judge to inquire whether the jury had reached a unanimous verdict on any charge. Guys, there was also no basis for the judge to inquire whether the jury had reached a unanimous verdict on any charge. What the hell is the point of trial then? Where is this coming from? This is the fucking Twilight Zone. You know what? I actually like the Twilight Zone. This is fucking hell. This is not the Twilight Zone. This is hell on earth. These fucking arguments. There was also no basis for the judge to inquire whether the jury had reached a unanimous verdict on any charge. Like, what planet are we living on? What's the point of the rules of criminal procedure if you're just gonna, at the end of the day, summarize what happened on your own terms and do what you want to do on your own terms? Continuing, nothing in the jury's 3 notes, quote, indicated agreement on any of the charges, end quote, or even an, quote, inkling of an indication of agreement, end quote. To the contrary, the first note said the jury had been, quote, unable to reach a unanimous verdict, end quote. Yeah, but again, on which count? Continuing, declaring outright that the jury had not reached a unanimous decision on any charge. The second note stated, quote, consensus is unattainable, end quote. But again, on which charge? There was not one charge against Karen Read. The prosecution and Judge Bev continue. Again, this is the prosecution's filing, but I keep referring to Judge Bev. She's not part of this filing, but I keep referring to her because their arguments are so similar. And again, they defend the judge and the judge defends the prosecution. Their relationship is so clear. Their partnership is so clear. The prosecution has done nothing in this filing but repeat circular arguments, and every single argument defends the ambiguity of the jury notes. The prosecution does not want to get to the truth of the jury notes. And again, guys, the defense in their filing, in their motion to dismiss, the motion they filed with the Supreme Court, the defense is primarily focusing on what happened post-trial. Because the jurors came forward, not all of them, but enough of them came forward to tell the world that they were unanimous on counts 1 and 3. That is what the defense is arguing, what happened post-trial. But the prosecution wants to obsess over what happened during trial. And yet what happened during trial, to me, should be completely thrown out because not a single rule was followed in the rules of criminal procedure. Not one single rule. And the jury notes were ambiguous, but the prosecution and the judge want to pretend that we should all know what the jury notes meant, even though not one single jury note was specific to any of the 3 counts against Karen Reed. Continuing. I'm just going to read that again. The second note stated, quote, consensus is unattainable, end quote, which would be a peculiar way of describing the jury's deadlock if consensus had in fact been attained on any charge. The third and final note, returned after the Tui Rodriguez instruction, stated the jury remained, quote, at an impasse, end quote, on, quote, the charges, end quote. The charges. Which charges? There were 3 charges. It's like in a way the prosecution is laying everything out. They're laying out what actually happened, and they're proving their own arguments mute. You know, just like when the prosecution alleges that the defense had multiple opportunities to be heard on the mistrial, when in fact, as the prosecution is laying out the timeline of what happened during trial, right before the mistrial, the prosecution proves in their own timeline of what happened that the defense actually had no opportunity. That in fact, before the mistrial was declared, there was no notice that there would be a mistrial. And right here, similarly, the prosecution continues to say, like we were right in our decision. The judge was right in her decision, and we defend the judge. And yet, as they lay out the timeline pertaining to the jury notes, the prosecution proves in their own timeline that the jury notes were not specific. They were ambiguous. And the jury notes leave all of us to assume that the jury were referring to all of the counts, when in fact we don't know which counts the jury members were referring to. Okay, continuing. Okay, I'm just going to read that part again. Stated the jury remained, quote, at an impasse, end quote, on, quote, the charges, end quote, not just a particular charge. As the judge found, the, quote, only reasonable interpretation of these notes, and specifically the final note, was that, and it skips right here, was that inquiry into partial verdicts premised on lesser included offenses due to heightened risk of coercion. Provides a case law. The judge recognized that even asking the jurors if they were truly deadlocked, let alone probing on which charges they were deadlocked, would have been coercive. Quote, in parentheses, such questioning, quote, would have implied to the jurors that the court wanted them to resume deliberations to reach a verdict, end quote. In parentheses, judge quote, interacts directly with the jurors while presiding at trial, end quote, and thus, quote, is ordinarily in the best position, end quote, to assess potential for coercion. In parentheses, quote, in many instances, asking a deadlocked jury about partial verdicts would constitute attempting to extract from the jury something that does not exist, end quote. Guys, I really feel like we're all being gaslit here. We're all being gaslit. We've gone down a fucking rabbit hole, thanks to the prosecution. We've gone down a fucking rabbit hole that, according to the prosecution, says you don't actually have to determine what the conclusion is on all the counts. I mean, guys, that's what I'm reading. I'm reading that the prosecution is actually implying that that the judge did not err when she failed to determine if there were verdicts on any of the counts. Again, it's like, what's the point of trial then? I'm going to continue reading, but I will be stopping soon. We're on page 32 of 77 pages, and so far, guys, I'm wasting a lot of time. I'm wasting my breath on non-arguments from the prosecution in their non-response, which was supposed to be a response to the defense's filing. The prosecution was supposed to have a relevant response to each of the arguments the defense team provided in their motion to dismiss. And so far, the prosecution has provided nothing but circular arguments and convenient interpretations of case law that often does not apply or really muddies the water to the extent that the prosecution actually has me thinking, like, what the hell is going on? What is the point of the rules of criminal procedure if you can just turn around as the prosecution and say, actually, the judge was not required to determine if there were verdicts on any of the counts? What? Again, I'm going to be stopping soon, and I might do a part 3. But it's like, to me, like, this is like toxic to my soul here. I feel like I'm being dumbed down by the prosecution. I feel like if I keep reading their words, I am going to be dumber. I'm going to read a little more and then call it, because I'm not sure this is good for any of us. The prosecution, again, is not after the truth. And we're 32 pages in. We're almost halfway through. We're 32 pages in. And what have we learned? Not a damn thing. But that the prosecution is willing to go above and beyond to protect their queen, Judge Beverly Cannoni. And Judge Beverly Cannoni, in her filings, too, is willing to go above and beyond to defend the prosecution. And neither of them want to do anything right here. None of them, neither of them, are in pursuit of the truth here. Continuing, the judge further recognized that, quote, to make such an inquiry on her own accord could impede upon the strategic decision of counsel to not make such a request, end quote. Given that defense counsel had previously accused her of, quote, directing a verdict, end quote, on the lesser included offenses because of how the OUI manslaughter verdict slip was initially worded, she was all the more attentive to avoid pressuring the jury. You see that again, guys. This is the prosecution once again throwing shade at the defense Given that defense counsel had previously accused her, the judge, of, quote, directing a verdict on the lesser included offenses because of how the OUI manslaughter verdict slip was initially worded. And again, guys, the way it was worded was rather suspicious. It was rather suspicious to David Yannetti, who has been a long-standing defense attorney in the state of Massachusetts. David Yannetti himself, being a defense attorney in the state of Massachusetts, had never seen a verdict slip like the one he saw during the Karen Reed trial. It's like the prosecution is saying the judge can do no wrong, and she did no wrong. The judge did not make any mistake, and the judge herself in her own filings, again, had similar arguments and made no mistakes. She took zero responsibility for what happened. They look like fools, really. How they so overtly defend one another, the judge and the prosecution. They make the suspicions, which are not just mine, but plenty of other people, they make those suspicions that they are in cahoots, they make those suspicions valid. What are we supposed to think reading these court filings? What are we supposed to think? When the jury has come forward, the jury has made themselves clear. The jury came to the defense and the prosecution, and the judge herself said that what the jury said was true and accurate. But neither the prosecution nor the judge want to do anything about those verdicts. They want to pretend that by bringing the jury back in an inquiry, in a post-trial inquiry, or in a post-trial evidentiary hearing, that we would be prying into the jury deliberations, when in fact that is not the true argument here. The prosecution and the judge, to me, have cemented, have validated my suspicions that they are in cahoots. They are not after the truth, and they are not to be trusted. They want to pull us into a rabbit hole of nonsense. They want to muddy the waters. They want to draw our attention to what happened during trial, when what's really at question here is what happened after trial. I'm going to stop it here, guys. And again, I might do a part 3. But I kind of feel like it's pointless. I kind of feel like, the prosecution named their arguments 1, 2, and 3. And they were non-arguments. They did not pertain to what the defense is asking for. They were they were pushback from what the defense is saying, but the prosecution took this opportunity to ask the court their own questions, new questions. And again, in my opinion, that is improper. In my opinion, if the prosecution had those questions for the Supreme Court, then the prosecution should have filed their own motion, separate and apart from the defense's motion to dismiss. The defense's motion to dismiss had specific arguments that the prosecution was supposed to provide response to, and instead of providing a rebuttal, the prosecution initiated new questions for the Supreme Court. I look forward to the defense's response, if in fact they intend to file a reply brief, and I hope they do. And again, they have until October 25th to file their reply brief, and I hope they do. I almost feel like in this 77-page document, and I haven't finished reading it, but from what I've seen so far, I almost feel like the prosecution wants to give the defense team busy work. It's just work to keep them busy. It's like It goes nowhere. It goes nowhere. Thank God for the ACLUM. You know, I understand some people don't trust them. And I'm not going to get into the abortion argument, but thank God for the ACLUM. Because again, their filing, their amicus brief helps the defense team. It helps Karen Read. And they provided case law and they provided examples of jury members coming back in a Massachusetts courtroom to determine what verdicts were post-trial. The prosecution and Judge Bev want to make it seem like the defense is speaking alien language when they ask for a post-trial inquiry. But the ACLUM validates the defense's arguments, and the ACLUM also requests the Supreme Court to order that the trial court, the Superior Court, hold a post-trial evidentiary hearing, a post-trial inquiry. Thank goodness for Karen Read's defense team, who have their head on their shoulders. They have their head screwed on right. And thank goodness for the ACLU, who came in with their amicus brief. And they too seem to have their heads screwed on right. Because the prosecution and Judge Bev clearly are insane. They are insane with corruption. They are insane with circular arguments that literally go nowhere. They go nowhere. Their arguments. It's a waste of everyone's time. It's a waste of the Supreme Court's time. 77 pages of this bullshit? Are you serious? I'm going to need to meditate or something. I'm going to need therapy after this. Thank you for watching.